Good day everyone. I am Aivan Frogosa. My report is all about Section 10. Section 10, Law on Speedy Trial, not a bar to provision on speedy trial in the Constitution. No provision of law on speedy trial and no rule implementing the same shall be interpreted as a bar to any charge of denial of the right to speedy trial guaranteed by Section 14 to Article 3 of the 1987 Constitution. Section 15. So, the constitutional right to speedy trial as guaranteed under Section 14 to Article 3 of the 1987 Philippines Constitution takes precedence over any statutory law or implementing role on the matter of speedy trial. No provision of law is on speedy trial and no role implementing such laws can be interpreted as a bar or limitation to the constitutional right to speedy trial. So, in other words, the constitutional guarantee of the right to speedy trial cannot be restricted, diminished, or negated by any ordinary legislation or administrative rules on speedy trial procedures. So, the constitutional right to speedy trial is a fundamental right that stands on its own and cannot be undermined by any statutory enactments. The constitutional provision is the primary and supreme source of this right, and it cannot be overridden by any lower level laws or rules. This clarifies that a person can still invoke their constitutional right to speedy trial, even if there are specific laws or rules in place regarding in speedy trial, as the constitutional guarantee takes precedence and must be upheld. Section 11, Order of Trial. The trials shall proceed in the following order. Letter A. The prosecution shall present evidence to prove the charge and in the proper case the civil liability. The prosecution has the burden of presenting evidence to prove two things. Number one is the criminal charge against the accused. Number two, the civil liability if applicable. In other words, the prosecution must present sufficient evidence to establish the guilt of the accused with respect to the criminal offense charge. Prove any civil liability that may arise from the criminal act. So that the prosecution has the burden of proof in a criminal case, both for the criminal charge as well as any related civil liability. They cannot shift this burden to the accused and must present to the necessary evidence to prove their case. Letter B. The accused may present evidence to prove his defense and damages, if any, arising from the issuance of a provisional remedy. In the case, the accused has the right to present evidence for two purposes. Number one is to prove their defense against the criminal charge, and number two is to prove any damages they have suffered as a result of the issuance of a provisional remedy in the case. Regarding the defense, the accused is entitled to present evidence to support their case and rebut the prosecution's allegations. This allows the accused to mount a defense and challenge the prosecution's evidence and arguments. Regarding the damages, if the case involved the issuance of provisional remedy, such as a preliminary injunction, or attachment, the accused has the right to present evidence of any damages they suffered as a result. This allows the accused to seek compensation for any harm or losses they incurred due to the provisional remedy. So the accused has the right to present evidence to defend themselves against the criminal charges. The accused can also present evidence to prove any damages caused by provisional remedies issued in the case. This ensures the accused has the opportunity to fully defend themselves and seek redress for any unwarranted harm caused by provisional measures taken in the proceedings. Letter C. The prosecution and the defense may, in that order, present rebuttal and surrebuttal evidence, unless the court, in furtherance of justice, permits them to present additional evidence bearing upon the main issue. So, the presentation of evidence in a trial, the order of a presentation, the prosecution presents its evidence first. The defense then presents its evidence. And the rebuttal and rebuttal. After the defense present its evidence, the prosecution may present rebuttal evidence to counter the defense's case. The defense may then present surrebuttal evidence to respond to the prosecution's rebuttal. Additional evidence, the court may, in the furtherance of justice, permit the prosecution or the defense to present additional evidence that is relevant to the main issue of the case. This allows the court to ensure that all relevant evidence is considered even if it was not presented in the initial rounds. The prosecution and the defense have the opportunity to present their respective cases in a structured manner. The rebuttal and surrebuttal stages allow the parties to directly address and respond to each other evidence. The court has the discretion to allow additional evidence if it is necessary to achieve a just outcome. This process ensures a fair and comprehensive presentation of evidence, allowing both the prosecution and the defense to fully argue their positions before the court. Letter D. Upon admission of the evidence of the parties, the case shall be deemed submitted for the decision unless the court directs them to argue orally or to submit written memoranda. The submission of a case for decision after the presentation of evidence, admission of evidence. Once the evidence presented by both the prosecution and the defense has been admitted by the court, the case is deemed to be submitted for decision, and then oral argument or the written memoranda. However, the court may direct the parties to either argue the case orally before the court or submit written memoranda or briefs. Submission for decision. After the evidence has been presented and admitted, the case is automatically considered submitted for the court's decision. Discretion of the court has discretion to require the parties further argue the case, either orally or through written submissions. This allows the court to obtain additional clarification or arguments from the parties before rendering its final decision. The purpose is to ensure that the court has all necessary information and arguments before It makes a final determination on the case. The court can exercise its discretion to have the parties further elaborate on the evidence and illegal issues if deems necessary for a well-informed decision. The last is letter E. When the accused admits the acts or omission charged in the complaint or information but interposes a lawful defense, the order of trial may be modified. Admission of the act or omission. The accused acknowledges that they committed the act or omission that forms the basis of the criminal charge, interposing a law defense. Despite admitting the act or omission, the accused claims that they have a valid legal defense that should exculpate them from criminal liability. Modification of the order of trial. The given accused's admission of the act or omission, the court may modify the normal order or trial proceedings. The modification may involve, for example, the accused presenting their defense evidence first before the prosecution presents its case. This allows the court to focus on the legal issues surrounding the accused's defense rather than spending time on establishing the basic facts of the case.